What if I told you that right now, at this very moment, there is a bill sitting in Congress that could fundamentally change what it means to be an American citizen? A bill that could turn your United States passport from a permanent guarantee into a conditional privilege that the government could snatch away from you years or even decades after you raised your hand and took the oath of allegiance. A bill that treats naturalized Americans as second-class citizens who can be stripped of everything they have worked for and sent back to countries they left behind 20 or 30 years ago. And the most terrifying part is that almost nobody is talking about it. This is not a conspiracy theory. This is not speculation. This is not clickbait designed to scare you without substance. This is real legislation that has been formally introduced in both the House of Representatives and the Senate of the United States. And if you are a naturalized citizen, if you are a green card holder planning to naturalize, if you have family members who went through the naturalization process, or if you simply care about the fundamental principles of American citizenship, you absolutely need to understand what is happening right now, because the implications of this bill are staggering, and the mainstream media is barely covering it. Welcome back to U.S. Citizenship and Visa. I am so glad you are here, because today we are going deep into one of the most significant pieces of proposed immigration legislation in recent memory. We are going to break down every single aspect of what this bill actually says. We are going to explain the legal and constitutional issues it raises. We are going to discuss who could be affected and how. And most importantly, we are going to separate the facts from the fear, because I know that topics like this can cause tremendous anxiety. And I want you to leave this video informed, empowered, and clear-headed about what is actually happening versus what is just political noise. The legislation I am talking about is called the Fraud Accountability Act. And on the surface, it sounds like something everyone could get behind, because who would oppose accountability for fraud? But when you actually read the text of this bill and understand what it proposes to do, you realize very quickly that this is not just about punishing people who commit fraud. This bill represents a fundamental philosophical shift in how the United States government views naturalized citizenship itself. And that shift has enormous implications for millions of Americans who were not born in this country, but who have built their entire lives here, raised families here, started businesses here, paid taxes here, and considered themselves every bit as American as someone whose ancestors came over on the Mayflower. Let me give you some background so you understand why this bill exists in the first place. Earlier this year, a massive fraud scandal made national headlines involving a daycare operation that allegedly defrauded federal nutrition and child care assistance programs out of millions of dollars, and several of the individuals involved in this scandal were naturalized United States citizens. And when this story broke, it generated enormous public outrage, because people were understandably angry that taxpayer money had been stolen through what appeared to be a sophisticated and systematic fraud scheme. And lawmakers responded to that public anger by introducing this legislation, which they framed as a tough-on-fraud measure, designed to ensure that people who commit these kinds of crimes face serious consequences. But here is where things get complicated, and here is where you need to pay very close attention, because what this bill actually proposes goes far beyond simply increasing penalties for fraud. Under current United States law, denaturalization, which is the legal process of revoking someone's citizenship, is an extremely rare and narrowly defined procedure that is almost exclusively used in cases where the government can prove that the citizenship should never have been granted in the first place. What does that mean in practical terms? It means that if you lied on your naturalization application, if you concealed a serious criminal history, if you committed marriage fraud to obtain your green card, if you misrepresented material facts during your immigration process, the government can potentially go back and revoke your citizenship on the grounds that you obtained it through fraud or illegal means. The key concept here is that current denaturalization law is backward-looking. It focuses on whether the naturalization itself was legitimate. It asks the question of whether this person actually qualified for citizenship at the time they applied. And if the answer is no, because they lied or cheated to get it, then the citizenship can be rescinded. What current law does not do, and what has never been part of American citizenship law, is allow the government to revoke your citizenship as punishment for crimes you commit after you have already become a citizen. Think about that for a moment, because it is absolutely critical to understanding why this bill is so radical. Right now, if you are a naturalized citizen and you commit a crime, even a serious crime like fraud, you face the same consequences as any other American citizen. You can be prosecuted, you can be convicted, you can be fined, you can be sent to prison, you can have your assets seized. But you cannot be denaturalized and deported because your citizenship, once legitimately obtained, is considered permanent. You made a mistake. You broke the law. You pay the price through the criminal justice system, but you remain an American. That is how it has worked for generations. And that framework reflects the fundamental principle that citizenship, once properly granted, creates an equal status that does not depend on future good behavior. The Fraud Accountability Act throws all of that out the window and proposes something entirely different. Under this bill, denaturalization would no longer be limited to cases involving problems with how citizenship was originally obtained. Instead, the government would be empowered to revoke citizenship from naturalized Americans who are convicted of certain fraud offenses that occurred after they became citizens. This means that if you became a citizen 20 years ago through a completely legitimate process, if you answered every question honestly, if you met every requirement, if you did everything right, and then 10 years later you are convicted of a fraud offense, under this bill, the government could strip you of your citizenship and deport you. Your 20 years of being an American, your American spouse, your American children, your American home and business and community ties, all of that could be erased because of conduct that had absolutely nothing to do with how you obtained your citizenship in the first place. But it gets even more concerning when you look at how the bill structures the denaturalization process itself. Currently, denaturalization cases are handled through the civil court system, which provides certain procedural protections and allows for careful independent review of whether denaturalization is actually warranted in a particular case. The Fraud Accountability Act removes denaturalization from the civil system entirely and embeds it directly into criminal proceedings. What this means in practice is that the same criminal court that convicts you of a fraud offense would also be responsible for immediately stripping your citizenship as part of the same case. There would be no separate civil proceeding, no independent review, no opportunity for a different judge to evaluate whether denaturalization is appropriate given the specific circumstances of your case. It would all happen at once as an automatic consequence of the criminal conviction. And the language of the bill makes clear that judges would have no discretion in this process. The bill does not say that a judge may order denaturalization if certain conditions are met. It says, the judge shall order denaturalization. And in legal drafting, the word shall is mandatory. It removes any flexibility or discretion from the decision-making process. If you are convicted of a qualifying fraud offense and you are a naturalized citizen, The judge would be legally required to revoke your citizenship, regardless of any other factors. Regardless of how long you have been a citizen, regardless of your family circumstances, regardless of your ties to the community, regardless of whether this was a first offense or whether you expressed genuine remorse. None of that would matter, because denaturalization would be automatic and mandatory. Now, let me tell you about another aspect of this bill that dramatically expands who could potentially be affected. And that is how the bill redefines what counts as qualifying fraud. Under current immigration law, for fraud to trigger serious immigration consequences, like deportability for permanent residents, there is typically a monetary threshold that has to be met. In most cases, the fraud has to involve a financial loss of at least $10,000 before it reaches the level of an aggravated felony with severe immigration consequences. This threshold exists for a reason. It distinguishes between major systematic fraud and minor offenses that might technically qualify as fraud, but involve relatively small amounts of money. The Fraud Accountability Act eliminates this threshold completely. Under this bill, fraud against private individuals, organizations, corporations, or the government would qualify for these extreme consequences regardless of the dollar amount involved. There is no minimum. There is no distinction between large-scale fraud and small-scale fraud. Any qualifying fraud conviction could potentially trigger mandatory denaturalization. Think about what this means in real-world terms. Someone who makes an error on a benefits application. Someone who exaggerates a claim on an insurance form. Someone who is involved in a relatively minor financial dispute that results in a fraud conviction. All of these people could theoretically face the permanent consequence of losing their American citizenship under the broad language of this bill. The removal of the monetary threshold means that the net is cast incredibly wide. And combined with the mandatory nature of the denaturalization provision, it creates a system where relatively minor fraud offenses could result in the ultimate immigration penalty of exile from the country you call home. And there is yet another provision in this bill that has legal experts particularly alarmed, and that is the retroactive application of these new rules. The bill does not just apply to fraud convictions going forward. It reaches back in time to cover convictions dating all the way back to September 30th, 1996. That is nearly 30 years of past convictions that could suddenly become grounds for denaturalization if this bill becomes law. Imagine someone who was convicted of a fraud offense in 2005, served their time, paid their debt to society, and has lived as a law-abiding citizen for the past 20 years. Under this bill, that decades-old conviction could be used to strip them of their citizenship today. People who made plea agreements and legal decisions based on the understanding that citizenship was not at stake could suddenly find that the rules have changed retroactively, and that old conviction now carries consequences that did not exist when they were convicted. At this point, I need to pause and provide some important context, because I know that everything I have described so far sounds absolutely terrifying, and I do not want anyone watching this video to panic or make rash decisions based on fear rather than facts. Here is the reality of the situation. This bill is not law. It has not passed either chamber of Congress. It is still in committee, which is the very early stage of the legislative process where most bills go to die without ever receiving a vote. Every year, hundreds and hundreds of bills are introduced in Congress, and the vast majority of them never become law. Many bills are introduced primarily for political messaging purposes, to allow lawmakers to demonstrate to their constituents that they are taking action on issues that have generated public attention, without any realistic expectation that the legislation will actually be enacted. This particular bill appears to be a direct response to the fraud scandal I mentioned earlier, and in the immediate aftermath of a news story that generates public outrage, it is very common for lawmakers to introduce aggressive legislation as a way of showing that they are doing something. That does not mean the legislation is legally sound or that it will survive the full legislative process. As the immediate anger fades and the bill receives more scrutiny, many of these reactive proposals lose momentum and quietly disappear without ever reaching a floor vote. So, while it is absolutely important to be aware of what is being proposed and to understand the implications if it were to become law, it is equally important to recognize that we are very far from that point right now. Beyond the political reality, there are also extremely serious constitutional problems with this bill that would almost certainly lead to immediate legal challenges if it were ever enacted. The United States Supreme Court has addressed the question of involuntary denaturalization in several landmark cases, and the precedents established in those cases create significant obstacles for legislation like the Fraud Accountability Act. In the 1967 case of Afroyim v. Rusk, the Supreme Court ruled that citizenship is a constitutional right protected by the 14th Amendment, and that Congress cannot take away citizenship from someone without their voluntary consent. The court held that citizenship belongs to the individual, not to the government, and that once citizenship is properly granted, it cannot be involuntarily revoked. This bill attempts to create exactly that kind of involuntary revocation mechanism, which puts it in direct conflict with established Supreme Court precedent. There is also a serious equal protection problem with this legislation. The bill would create two fundamentally different classes of American citizens with dramatically different vulnerabilities. Natural-born citizens would remain completely protected from any risk of losing their citizenship, no matter what crimes they commit. A natural-born citizen could commit the exact same fraud offense and face criminal penalties, but their citizenship would never be at risk. Naturalized citizens, on the other hand, would face the constant threat that a fraud conviction could result in losing everything, not just their freedom, but their very identity as Americans. The Supreme Court has repeatedly affirmed that naturalized citizens are entitled to the same constitutional protections as natural-born citizens. And creating this kind of two-tiered system, where citizenship is conditional for one group but permanent for another, raises profound equal protection concerns that courts would almost certainly scrutinize closely. For these reasons, many legal experts and constitutional scholars believe that even if this bill somehow passed Congress and was signed into law, it would face immediate and substantial court challenges and would likely be enjoined from taking effect while those challenges work their way through the legal system. The constitutional vulnerabilities are so significant that the practical enforceability of this legislation is highly questionable, regardless of what happens in the political process. But here is why I think this bill still matters, even if it never becomes law. And this is the part of the conversation that concerns me most when I think about the broader trajectory of immigration policy in the United States. For decades, there has been a clear conceptual distinction between deportation and denaturalization. Deportation is an immigration consequence that applies to non-citizens. It is about managing who gets to stay in the country based on their legal status. Denaturalization has been something completely different, a rare and narrow legal tool used only to correct situations where citizenship was improperly granted in the first place. Denaturalization was never designed to be punishment. It was designed to be a correction of past errors in the naturalization process. What this bill represents is an attempt to blur that distinction and to transform denaturalization into a punitive tool that operates like a super deportation for naturalized citizens who commit certain crimes. It treats citizenship not as a permanent status earned through the naturalization process, but as a conditional privilege that can be revoked based on future behavior. That conceptual shift, regardless of whether this particular bill passes, signals a concerning direction in how some policymakers are thinking about naturalized citizenship. It suggests that there are people in positions of power who view naturalized Americans as fundamentally different from natural-born Americans, as somehow less fully American, and therefore more appropriately subject to the threat of exile as a consequence for criminal conduct. If a naturalized citizen commits a crime, the criminal justice system already has all the tools it needs to impose appropriate consequences. Prosecutors can seek substantial fines. Courts can order restitution. Judges can impose lengthy prison sentences. The idea that we need to add citizenship revocation on top of all those existing penalties suggests that the goal is not really about accountability for fraud. It is about creating a separate and more severe category of punishment that applies only to people who were not born in this country. And once you establish the principle that citizenship can be revoked for post-naturalization conduct, once you cross that line, where does it end? If fraud can trigger denaturalization today, what other crimes might be added to the list tomorrow? The precedent this bill would establish is far more dangerous than the specific provisions it contains. So, what should you take away from everything I have told you today? First, and most importantly, do not panic. Nothing has changed yet. The rules governing denaturalization remain exactly as they have been. This bill is a proposal, not a law, and it faces enormous political and constitutional obstacles. If you are a naturalized citizen, your citizenship is not at risk today because of this bill. Second, stay informed. Understand what is being proposed so that you are not caught off guard if this legislation advances or if similar proposals emerge in the future. Knowledge is power, and understanding the landscape helps you make good decisions about your own situation. Third, if you have concerns about your specific circumstances, particularly if you have any kind of criminal history or pending legal issues, consult with a qualified immigration attorney who can give you personalized advice based on the facts of your case. Do not rely on general information from videos like this or from friends and family when it comes to something as important as your citizenship status. I want to thank you for watching this entire video and for trusting U.S. Citizenship and Visa to bring you this important information. If you found this breakdown valuable, please subscribe to the channel and hit the notification bell so you never miss an update on critical immigration developments like this one. Share this video with anyone you know who might be affected or who cares about these issues, because the more people understand what is happening, the better equipped we all are to respond appropriately. Drop a comment below and let me know your thoughts on this legislation and whether you have concerns about how it might affect your community. Staying engaged, staying informed, and staying connected is the best defense against both the real threats and the unnecessary fear that topics like this can generate. I will continue monitoring this bill and will bring you immediate updates if anything changes. Until next time, stay informed, stay empowered, and remember that knowledge is always your greatest protection.